Okay, so this recording has started. So I'd like to welcome everybody here to the Cabinet, the Rights of Way Committee. Welcome to this digital meeting of the Rights of Way Committee. It's being held via Microsoft Teams here on Friday, the 15th of January. Just to confirm that this meeting will be recorded and made available to view via the Council's website, except for discussions involving confidential or exempt items. Therefore, the images, audio of those individuals present and or speaking will be publicly available to all via the recording on the Council's website. If members lose connection during the meeting, please make every attempt to reconnect. However, the meeting will continue as long as it remains quorate. Committee services staff are available and will be able to assist you to reconnect if necessary. Can I remind everyone to please mute their microphones? For Cabinet members, if you can keep your cameras on, and if everyone else can keep their cameras off, unless you're being invited in to speak or present reports. Today we'll be using a show of hands for the voting, as there's just a few of us here. So first of all, I'm going to go through a roll call of who's present, and if you could all introduce yourself. So I'll start with Phil.
Hi, thank you, Chair. I'm Phil Griffiths. I'm the countryside manager, and the Rights of Way portfolio falls under me. So I'll be leading on this report with Stefan Denbury, who is here to answer any detailed questions. Will introduce himself later.
Yeah, go on, Stefan.
Thank you, Chair. Stefan Denbury, Countryside and Rights of Way Assistant.
Thank you, Stefan. And Martin.
Thank you, Chair. Martin Woodland, Senior Solicitor, Property, Highways and Planning. My function here today is to advise the Chair and members of the committee in relation to matters of law and procedure.
Thank you, Martin. And Sharon?
Morning, I'm the Committee Services Officer.
Thank you, Sharon. And Charlotte?
Morning, Chair. Charlotte Evans, Committee Services Officer.
Okay, and now we'll go through the councillors present. My name is Sean Morgan. I'm Deputy Leader of the Council and Cabinet Member for the Economy and Enterprise. John? You're on mute, John.
Apologies, yes. Morning, I'm John Ridgewell, Cabinet Member for Environment and Infrastructure.
Lisa?
Good morning, thank you, Chair. I'm Lisa Phipps, the Cabinet Member for Homes and Property.
Colin?
Good morning, Councillor Colin Gordon, Cabinet Member for Corporate Services.
Leonard?
Morning, I'm Leonard Stenner and Cabinet Member for Finance, Performance and Customer Service.
And Shane?
Thanks, Chair. I'm Councillor Shane Cook. I'm the Councillor for Morgan Jones Ward.
And then if we can move to the guests, Paul.
Good morning, Chair. My name is Paul Wells. I own a section of the land on the site we're talking about.
Thank you, Paul. Tony.
Hi, I'm Tony Taylor-Wells. I'm the Senior Technical Manager for Taylor Wimpey.
And David.
Thank you, Chair. I'm David Shakespeare. I'm a solicitor at Osborne Clark, acting for Taylor Wimpey.
And then I believe we've got Maggie Thomas. Hello, Maggie. Are you there? And I've seen somebody called Simon come up as a guest. I don't know who Simon is. Do you want to introduce yourself, Simon?
Chair, Simon Gray, I'm Managing Director of Landmore Homes, the second application you have.
Right, thank you, Simon.
Thank you.
Okay, thanks everybody. We have got Maggie Thomas here, who I believe is it Open Spaces? Representing the Open Spaces, Charlotte, or?
Yes, Chair, I believe so. I think she's
Yeah.
observing the first part of the meeting.
Just observing the first part of the meeting. That's no problem. Okay, so now we all know who's here. I don't believe we've got any apologies for absence.
Someone else waiting to come in, Chair. He's in.
Okay. That's Keith Donovan, I believe. Hello, Keith.
Hello.
Hello, is that Keith?
Yes, it is. Yeah.
Hello, Keith. Would you like to introduce yourself?
Well, I'm Keith Donovan, and I'm chairman of Gethlygate Ramblers.
Lovely. Okay, thanks, Keith. Unfortunately, you've missed all the introductions of the rest of us. You'll probably catch up with it as we go along.
I'm not used to this sort of meeting.
No worries. Okay, thanks, Keith. If you could just make sure your microphone is turned off when you're not speaking, otherwise we have feedback.
Yeah, okay.
Okay. Okay, so I think we've gone through apologies for absence, and we've got no apologies. Declarations of interest. Councillors and officers are reminded of their personal responsibility to declare any personal and/or prejudicial interest in respect of any item of business on this agenda in accordance with the Local Government Act 2000, the Council's Constitution and the Code of Conduct for both councillors and officers. If you could put your hand up if you have a declaration to make. Councillor Gordon.
Yeah, thank you, Chair. On advice from the monitoring officer and the legal officer, I'm going to have to declare interest on item 4, as Mr. Donovan is known to me and we live quite close together and we are quite friendly when we meet up. So with that, Chair, I'll have to declare a personal interest. So I believe in the meeting, and on the next item, if you can contact me, I'll log back in.
Sorry.
I said I'll be leaving the meeting.
For agenda item 4.
On item 4, I'll be declaring personal interest. And once this item is complete, if you contact me, I will log back into the next item.
I thought item 4 was the last item.
No, we got 2 items on today, Chair. Down in some place called Bedworth. I don't know where that is.
Yeah, I know we got 2 things on here. I'm just, where am I? Okay. I'll mix my papers up, I have. So, sorry about this. So the Landmore, you can come back in on the Landmore Homes development, yeah?
Yeah, well, I hope so. Well, if you contact me, if you send me a text or give me a quick ring, I'll log back in.
Okay, all right.
I leave the meeting now then.
Okay, thanks, Colin. Martin Woodland.
Yes, Chair. For a point of clarity as well, the monitoring officer has advised Councillor Gordon he's also got a prejudicial interest as well, so it's both a personal and a prejudicial interest, so that's why he's been advised to stand down. Thank you, Chair.
Okay, thanks, Martin. Could I just check with you as well, Martin, that Councillor Stenner didn't sit through the first part of the item on the Caerphilly on the rights of way 54, was it? But Councillor Stenner is okay to take part in this and vote on this, even though she wasn't in the first part of the meeting. Is that correct?
Well, I understand, Chair, that today that the matter will be considered totally again, basically from scratch.
That's correct.
Obviously advising members what went on in the previous meeting. So from a point of view, I don't see any point in Councillor Stenner taking part because she's going to be totally appraised as to the facts and the issues, Chair.
Yeah, okay, thank you, Martin. Next thing on the agenda is to approve the minutes of the Cabinet Rights of Way Committee held on the 2nd of October. And we'll go through them page by page. So page 1, page 2, page 3, and page 4. Would anybody like to move those?
I'll move those, Chair. Lisa Phipps.
And a seconder?
Chair, second those.
Thank you, John. And all those in favour of moving the minutes, just give us a wave. Thank you.
Chair, while I'm on the line, I need to keep my camera off, I think, to keep my signal going. Apologies.
No worries. Okay. Thanks, John. And Shane has disappeared on us, or?
Sorry, Chair. No, I can keep my camera off as well. It's not
Okay.
worth leaving it on. I got no connection.
As long as you agree the minutes, yeah?
Sorry, Sean. Yeah, I agree, mate.
Yeah. Okay, thanks. And now we're going to move to agenda item 4, which is the deferred public rights of way Cabinet Committee meeting from the 2nd of October. An application for an order under Section 119 of the Highways Act 1980 to divert public footpath 54 Caerphilly affected by development granted by planning permission. So I'm going to ask Phil Griffiths to introduce this. Kick us off.
Thank you, Chair. As you say, this is an application report regarding footpath 54 Caerphilly. This is located on the Kingsmead development near the Catnick site, and the purpose of the report is to consider the diversion of this footpath of development under Section 119 of the Highways Act 1980. A decision upon which was deferred by this committee at its meeting of the 2nd of October 2020. This report of the 2nd of October is appended as Appendix 1. That's pages 9 to 38 of your reports. Members visited the site as part of that committee meeting on that morning. Now, recall from a physical description, moving from a south to a northerly direction, it's a proposal to go up a ramped zigzag section along an estate road, and basically coming in between properties via back gardens. The actual report was deferred to allow parties to try to progress a transfer of land known as the Wildlife Corridor, which would allow for an alternative diversion of footpath 54, which had been discussed previously. Following the agreed 3-month deferral, agreement hasn't been reached between the parties nor the land transferred. And as such, we are proposing this report before you today. The committee are basically asked to consider 4 options before them in terms of a potential diversion, which can be seen in your reports as appendices 2, 3, 4 and 5. In terms of options C and D, these are actually similar routes, but utilise a different road crossing point along Rue Coitier, utilising the southern section of footpath rather than the northern section along the main access road, and the western section as opposed to the eastern along the dead end cul-de-sac. This latter option would provide a more commodious route.
Phil, could I just stop you there? Sorry.
Certainly, Chair.
Could you explain the difference between options C and D again? Because I'm not sure if there's a confusion here, if they are mixed up.
Yes, Chair. I was going to come to that as my next point.
All right. Okay. Sorry.
Please note in your report packs under paragraph 5.9, option B should in fact be appendix 3 and option A should be appendix 2. So I hope that clarifies that point, Chair.
Say it again, sorry, Phil. Appendix.
Under paragraph 5.9, option B should in fact be appendix 3 and option A should be appendix 2.
Okay, yeah.
So effectively, the difference is, Chair, is that we're utilising the southern rather than the northern side of the main access road. Once you've come up that zigzag ramp, we cross 30 yards further up the road, and we use the western side rather than the eastern side of the cul-de-sac as was in the original report. Now that's been included because it's actually probably better in terms of usage and sort of the Qualities Act, and the route can be marked out easier on site by delineation. So the routes are exactly as discussed on site, which members saw, and it basically, in summary, again, it comes up as zigzag, utilises the highway proposals, the highway routes as built on site, and then goes through rear garden, and the choice is whether we go left or right at the rear garden at the end of the cul-de-sac. Both routes join footpath 56. The one option follows the existing line on the definitive plan, which goes through an area which has been dug out, whilst the other route just abuts footpath 56. So there's less physical works on site. What I would say is that there are possible costs in terms of for the authority in terms of making an order, whichever way members choose to go with this. So the committee is required to determine effectively whether to make an order under section 119 of the Highways Act 1980 to divert footpath 54, and if so, which of the options should be provided, A, B, C or D. Secondly, to make an order under section 118 of the Highways Act 1980 to extinguish footpath 54 as it is no longer needed, or option 3, to take enforcement action to remove the obstacles on site, which are effectively 3 houses which are currently unoccupied, 3 garages, and some realignment of garden boundaries, or fourthly, to make an order under section 119 of the Highways Act to divert footpath 54 onto a different route to that sought by the applicant, the route of which can be determined by this committee. Officers are of a mind, should members decide to proceed with making an order, then the option provided before you, options C and D, are preferred for reasons of accessibility and equality that I sort of outlined earlier. Thank you, Chair.
Yeah, okay. Thanks, Phil. Okay. Who will I bring in next to speak on this? I think I'll ask Mr. Paul Wells if you could make your representation.
Thank you, Mr. Chairman. Firstly, if I may, start with the proposed diversion, which is shown as options A, B and C, and D, in fact, on appendix 2 to 5. There are several issues that I have on this section. It's a large section goes down the shared access where the footpath is only 1 metre wide and the road has been reduced in width. If you go to that site on the weekends or the evenings, there's always cars parked on the footpath.
Okay, can I just, on what exact point are we talking about here? If you look at the maps, there's B to E or there's D to C.
It's D to E. On section D to E, where it goes up, there's a reduced access, reduced highway there.
Yeah.
If you go there on the weekends or on the evenings, there's always cars parked on the side. And that means that any pedestrian has to go around the cars. And because it's a reduced highway, you end up in the middle of the highway. And then you go around. The second issue I had is up at the far end of the site, at section A and C.
Yeah.
There are 3 houses in that area. Each of them have a garage, and there's a short area of private drive. Under the planning application, each has 3 off-street parking spaces. So there's 9 vehicles parked in there, and they can only enter the site or leave the site. They have to reverse. There's no turning circle. So whilst it may work on paper, in reality, when someone parks slightly out of line and cars are manoeuvring, it's dangerous for any potential pedestrians walking through this very tight area. So I have concerns there. I also have concerns on the access ramp at the other end of the site.
Between E and B, yeah?
E and B, yes. As mentioned in the meeting on the 2nd of October, a section of that ramp has been built on land that is in our ownership. It's registered with the land registry in our ownership. At the meeting, Tony Taylor Wells stated that she felt that that land was owned by them and there was a mistake with the land registry. As I believe as today's date, there's been no application to the land registry to rectify that alleged mistake. In fact, I can confirm that Taylor Wimpey did amend their planning application to take into account that section of land early on in the development. So if the authority were mindful to grant the application and put the footpath up the ramp, then it should clearly show the footpath within Taylor Wimpey's ownership. They have actually given a plan showing that it can be done that in that manner. So if I may now, Mr. Chairman, could I refer to the actual wildlife corridor and the proposal?
But before we go on to that, Mr. Wells, I would just like to ask Mr. Martin Woodland regarding the ownership of the land. Martin, we are here as a rights of way committee. Can we grant a right of way over land of which we know nothing about the ownership?
I understand, Chair, it's possible for you to do it. You know, obviously other matters would have to be taken into consideration at a later stage concerning land ownership.
So is the land ownership something between the two parties, or is it something that the council also has to consider?
The land ownership is a matter, Chair, between the two parties.
Right, okay. Thank you, Martin. Okay, carry on, Paul.
Thank you, Mr. Chairman. Whilst I appreciate Martin's comments that the dispute will be between the two parties, obviously if an order is given and somebody's put on our land that we don't want, then we will obviously be objecting to that.
Yeah, I'm guessing, sorry to cut across you there, Paul. I don't know, and I'll have to ask Martin if this is how it works. Somebody can apply for planning permission on any piece of land, anywhere. They don't need ownership of the land. And the council can grant planning permission because the granting of planning permission only says that the planning is viable. It doesn't mean that somebody can then go ahead and build a house on that land, because obviously they don't own it if they don't, but they can apply to build a house on land that doesn't belong to them, and the council can grant it. But whether they build on there or not is then a matter between them and whoever the legal owner of the land is. So is that the same situation we are in here, Martin?
I understand this is the same principle, Chair, but you know there are matters pertaining to compensation under the Highways Act.
Could you explain them further then? Again, does that involve the planning committee?
I don't think it involves planning.
Not the planning committee.
Chair, it's no, it wouldn't involve this committee at all.
No. Okay. All right. Okay. Carry on, Paul.
Thank you, Mr. Chairman. There's a similar dispute as well on the boundaries at the other end of the site on C and A. Again, there's a level difference. In the original planning application, when this site went to planning, there was a retaining wall shown in that area. Unfortunately, the retaining wall was never constructed, and as a consequence, there was an encroachment onto our land. So the difference in level now is supported by material that has been deposited on our land to enable and support Taylor Wimpey's raised level. We have been trying to resolve this with Taylor Wimpey to no avail. So I do not think the levels at that end of the site work either.
Okay, if I can stop you there. Again, I'm going to ask Mr. Woodland, is this pertinent to this committee?
Can you pose the question again, Chair? Because my sound system went a bit strange there.
Sorry, Martin. Mr. Wells is talking about, again, the land ownership and a retaining wall, and the fact that Mr. Wells says that Taylor Wimpey have infilled a piece of land in that area that belongs to Mr. Wells and not Taylor Wimpey. So it's basically, I'm asking the same question again. Is this pertinent to this committee?
I don't think it's pertinent, Chair. It's a private land issue again.
Okay, thank you, Martin. Carry on, Paul.
Thank you, Mr. Chairman. May I now refer to the actual wildlife corridor, which is the preferred option? In our
is there any point in going over the wildlife corridor? Because I believe in the last meeting, we gave both parties 3 months to go and discuss the wildlife corridor, which was the preferred option. We could see, certainly the Rights of Way Committee could see that that might be the better option. But we gave 3 months for the two parties to find a resolution on that. And from my understanding, no resolution was found. So do we need to therefore go back over that same ground to talk about the wildlife corridor now?
Yes, I think there are some relevant points, Mr. Chairman.
Okay, go on, Paul.
Following the meeting, both parties instructed solicitors. On the 5th of October, I received an email from Tony Taylor Wells enclosing a plan from Mr. Dembry showing that there was an additional section of land that was required. You will no doubt recall at the last meeting, Mr. Chairman, you pointed out on the screen the proposed route for the diversion on the wildlife corridor. Well, there was an additional section of land that was required. So following the email from Tony Taylor Wells, I spoke with the footpath officer and he confirmed that that was required. I then followed that up in emails asking for clarification, because if it changes from what was actually said at the committee meeting and additional land was required, I needed to know that because we had to transfer that additional land. And the response I ended up having was that it would be the committee's decision as to whether the additional section was required. And as of today's date, I still don't know whether the additional section of land was required. But notwithstanding that point, the agreement with Taylor Wimpey fell down because at the last meeting, I was under the impression, and I made it clear, I thought, when I made my report, that we would be requiring the legal fees to be paid and all other contractual obligations would be set aside and the land would be transferred at nil value. Unfortunately, it was Taylor Wimpey's view that it was going to be that all contractual disputes were set aside and the land was transferred at nil value, and I didn't recover the legal costs that had been paid. So, to summarise where we are, that is a difference. I was looking for my legal costs to be paid, and Taylor Wimpey wasn't. So, as it stands at the moment, the wildlife corridor is obviously the best option. It's the safest option. It's what the local societies want. It's what the members want. It's what the residents require, and the general public in large want that to work. The only reason it won't work is because Taylor Wimpey do not want to pay the £40,000 legal costs that have been expended. That site has had 202 houses built on it, generating a project income of in excess of £55 million. And I believe that it's not unreasonable to request that Taylor Wimpey pay the legal fees and transfer the authority ask for that footpath to go along that route. It's already gone through consultations. There's no consultation problems. It complies with the Welsh Assembly guidelines, whereas the other options don't comply with the guidelines. So I honestly believe that that is the best option for the committee. I'm sorry that I'm so passionate on this, Mr. Chairman, but I've lived on that site for over 20 years, and I spent the last 10 years trying to get this development to its conclusion. And I'm passionate that the local community get what they deserve, and in fact what they were promised when the site was being developed. Thank you, Mr. Chairman.
Okay, thank you, Mr. Wells. Okay, could I ask Tony Tony Taylor Wells to come in and respond to that, please?
Thank you, Mr. Chair.
Chair,
I'm just
Tony, sorry, do you want me to just pick up that point first and then you can carry on?
Yeah, so I was just going to introduce you to David, who's obviously our legal representative. Obviously, we're all fully aware about the privileged negotiations and previous contractual frustrations that obviously we've all experienced in the past, which has kind of led us to this issue. So I'm going to refer you straight to David from a legal perspective in terms of Paul's point in terms of money, and then I can obviously finish reading off and picking up on the other points that Paul raised.
Chair, sorry, your mic's muted.
Sorry, there we are. Thanks. Welcome, David. If you'd like to pick up the point regarding the wildlife corridor and the payment of.
Yes, of course. So obviously, I wasn't at the last committee meeting, but Tony's briefed me and I've read the minutes. Now, my understanding of the suggestion, the offer that was made at the previous meeting by Mr. Wells was that he was prepared to transfer the wildlife corridor to Taylor Wimpey to enable that diversion to take place. The proposal, at least the proposal that we understood and the proposal that's minuted, is that that would be transferred at zero consideration and Taylor Wimpey would pay his transaction costs, his conveyancing costs of dealing with that transfer. Now, the costs that Mr. Wells is referring to are legal fees that he incurred with his lawyers in relation to, it's connected because it all relates to a number of issues relating to this site, but a contractual dispute or a number of contractual disputes between him and Taylor Wimpey. Now, as Tony has said, The contents of those negotiations and the detail of it is a matter which is privileged between Taylor Wimpey and Mr. Wells and his companies. Those negotiations ultimately weren't successful. What he's attempting to, the money he's referring to here is money that he's incurred in relation to legal fees relating to that dispute, which he wants to recover. Now, you know, he may want to recover it, but he's got no entitlement to recover it. And effectively what he's trying to do here is to ransom Taylor Wimpey by requiring them to pay that in order to unlock the wildlife corridor. Now, as Tony will explain, that's something Taylor Wimpey is not prepared to do. It's not prepared to pay a ransom to deal with this, and it's clear that these issues and disputes with Mr. Wells have been running on for years and years. I've been dealing with it for many years, and that is not something that's going to be resolved unless he changes his position. The proposal that was made would have been acceptable to transfer for zero consideration if we paid his transaction costs, but that's simply not on the table, and it's not something, as you've explained, Chair, it's not something which is before the committee today. It's simply not been possible to move forward with that, and that was clear. I believe you were, officers were updated about that. That was clear within a couple of days of the last meeting that difference is simply not bridgeable.
Okay, thanks, David. I can see Councillor Phipps is indicating. Would you like to come in, Lisa?
Yeah, thank you, Chair. I put my hand up immediately after Phil presented the report because my question. Sorry, no, it's fine. No, it was because I wanted to ask why hasn't the issue with the green or the wildlife corridor been resolved, and that's sort of been answered now. Thank you.
All right, there we are. Okay.
But I'd also like to ask about the private land issues, which you've touched on. Why? I guess that my question is, why are we being asked to determine something when there's these issues in the background? But that's already been touched on. Thank you.
Yeah. I think the idea being here that we can grant that as a right of way, but then it's for Taylor Wimpey and Mr. Wells to determine the ownership of the land before Taylor Wimpey can implement it, or if they implement it at their own risk. If they are putting it over land that doesn't belong to them, but they are telling us that they can implement it. So in either way, it's between the two parties.
And if I can just come back with a question for Mr. Wells, is that if things had been resolved with the green corridor, you would have been happy for the zigzag for that to go ahead? Because I know that you mentioned there's a dispute on that land, but if the green corridor was to be progressed, you'd be happy to waiver that. Is that correct?
No, what happens there, if we diverted it through the green corridor, that would negate the need for the use of that ramp.
I thought the zigzag was required on all routes.
On all routes that we've got here in front of us today to determine, yes, right. But not on the route that we talked about in the last committee meeting, which is where it goes from.
I know the one green wedge to the other.
Yeah, right. Yes. It follows the river down to the green corridor.
Right, okay, thank you.
Okay.
Mr. Chairman, can I jump in there? Yeah. Actually, Councillor Phipps was right. The ramp is staying regardless of whether it went up there. That was to comply with the Disability Act. So the ramp was always going to stay, even if the wildlife corridor option was chosen. And to answer the question, yes, I was happy if the wildlife corridor went, that the ramp could stay as it is, and that land would transfer. In fact, there was an agreement with Taylor Wimpey that they were going to take that land off us and purchase it at a nominal cost to save them doing the work. So yes, the answer was the ramp would stay and we would transfer that land. Thank you, Mr. Chairman.
Right, okay. And Tony Taylor-Wells.
Chair, sorry, if I could just pick up the land ownership points, and then I will shut up. So you've got the two issues. You've got the small area of land on the ramp. Now, there's two alternatives there. One, that Taylor Wimpey can slightly change the foundations of the ramp so that.
Why are we talking about this?
Responding to the points that Mr. Wells has made. So he's complaining that part of the route of the ramp would cross an area of land which is still registered to him. If Taylor Wimpey had to, they could alter the foundations of that ramp so that it is not constructed on the land that is currently registered to him. When Mr. Wells explained the position as he understood it in relation to that land, he's wrong, I'm afraid. That land should have been transferred to the land he contracted to sell to them, but there's been a mistake in the plan, so it hasn't been transferred. So Taylor Wimpey's options there are either to bring proceedings against him to require that to be transferred, or to alter the ramp if he was to try and prevent them from using that route. And quite put simply, Taylor Wimpey would take the path of least resistance. They'd take the cheapest and most efficient option. So if it was easier to alter the ramp, they would do that. If they needed to resolve that issue legally, they would do that. In relation to the land at the north at point C, my understanding is that what Mr. Wells is complaining about is an area of land which isn't on the proposed route of the diversion. It's on the adjoining land that he still owns. The route, now it's been altered, of the diversion does not cross his land, but he has an issue in relation to the retaining wall and the levels. Now that is not relevant to the route of the right-of-way, but it is an issue between Taylor Wimpey and Mr. Wells as to whether they've done what they should have done. Taylor Wimpey's position is that they have, and he's wrong, but it doesn't actually affect, as I understand it, the route of the right-of-way that the committee is being asked to decide upon in relation to this diversion.
Okay. Thanks very much for that. Just for clarity, this is the map that I believe Mr. Wells, and are we talking about this small patch of green land here?
Yeah, that bit of green land was part of the land. So all of the land there that doesn't belong to the council, I think some of it did, but all of the land that was owned by Mr. Wells and by his companies was contracted to be sold, transferred to Taylor Wimpey. All of the rest of the land has been, but when the transfer plan was prepared, somebody, I don't know who, but somebody's made a mistake, and that little bit of that tiny bit of land has been left out in the gap between. So when that land was transferred, there were two different transfers, and the two plans didn't quite match up. So that's how you've ended up with that bit of land that hasn't been transferred. So that bit of land is left in Mr. Wells' original title, but it shouldn't have been, because everything should have been transferred.
Okay, thanks. And again, I will reiterate that ownership element of it isn't any way relevant to this committee. Mr. Keith Donovan. You're on mute, Mr. Donovan.
I can't quite understand why we're talking about these alternative routes. Taylor Woodruff came up with an agreement initially, and in that and that was to do this wildlife corridor, which I must compliment them on. It was their idea and not ours. We had objected and offered another route, but they came up with an even better one. Now, the fact that that you're discussing this now, that there was another landowner involved. The landowner involved, and that Taylor Woodruff giving us this wildlife corridor, giving the wildlife corridor, committed to that, but because they didn't own the land, that's irrelevant in my opinion. In my opinion, there's only one route that this should be taken on, and that is the corridor, because that is what they made the agreement on. I don't see why the council should be helping them out to sell their houses now, as it happens. I mean, they've got themselves into a state. It's their problem to get out of it, not the council's. I wouldn't have thought. As I'm listening to this, it seems to me as if the committee are being asked to help Taylor Woodruff out, not Taylor Woodruff, Taylor Wimpey. And in my opinion, you shouldn't be doing that. We made an agreement was made with them. That's what that really is as far as we're concerned anyway. And I do honestly believe that the council historically have been a little bit too lenient with in pathways and diversions. I've been a bit too lenient with developers, and we get the feeling that the developers' attitude is such that, oh, don't worry about it, we'll settle it later. And I do honestly feel that the council on this particular one now shouldn't be helping the developers to get out of a problem which is they instigated in the first place. That's where we stand, and I do honestly believe that it's time that developers thought, be careful with Caerphilly Council, because they won't let you off the hook.
Okay.
That's, I think, where we should be.
Thank you, Mr. Donovan. Thank you very much. You make your representation well. Councillor Cook.
Thanks, Chair. Now, I just want to remind the committee that this issue is affecting residents. It's affecting their mental health as well, because I know a lot of residents in our area, if you look at the plans, you can see a number of houses that will be affected by the change to this path. So if you see all the houses in there, they've all made representations to myself and Councillor Pritchard, and they're all very upset at what's going on. Now, I'm concerned with antisocial behaviour. I'm concerned with people walking that route in the night, walking down from A through the street. They've had a lot of problems with burglaries in the area already. And if this is opened up, I think it's going to make it worse. And I think the residents need to be thought of before any decisions made. Now, I understand there's a lot of technical issues and issues of money and land, but in the end of the day, it's affecting the residents. And I think both parties should try their best to come to an agreement to help the residents.
Okay, thank you, Councillor Cook. Tony Taylor-Wells.
Hi, sorry, Chair. It might be worthwhile bringing Stefan and Phil back into this, obviously, because these objections in terms of residents have been raised in the past at the last committee.
Yeah, I'll discuss them later. I was hoping that you would be replying to the restricted road, the 9 vehicle parking bays, which are going to be, the difficulty with walking, those things, and I would also like to know that when these houses were sold, did the people who purchased these houses, were they aware that there was going to be a right-of-way running up their street and across their parking bays, basically?
At the time of saleability on those houses, no, there wouldn't have been this plan in place, because we always had sort of a background agreement with Mr. Wells until it became obviously a contractual frustration, which led to us not agreeing. But whilst there wasn't that proposal for the new route, obviously the existing route have always remained to be in place not too far from it. So whether we deliver on this proposed route, obviously, which is what we're putting forward, or, you know, at worst case that, you know, this was completely thrown out and, you know, it all led to Taylor Wimpey having to remove houses, we need to remind ourselves that the existing route is still very much present and will be there and always has been. And so just going back to your other point in terms of the cul-de-sac, obviously when we walked the site, I think it was back in October.
Yeah.
We've developed some construction plans, which, because we still have control over a part of land in that area, to effectively redesign and reconstruct to mitigate for any health and safety concerns with construction traffic. Any pedestrian accesses that would need to be maintained in terms of the public footpath route running through that. And we would also redesign the parking to facilitate those houses, which obviously would also be very prominent and knowing when obviously those saleability of those houses went up. So, you know, we do have a plan. It does work, you know, from a physical sense. I can understand what Paul is saying, but we do have a plan that can be demonstrated and developed on land that's within our control, to facilitate that public route going through there.
Okay. Do you want to reply to the question about the restricted road there near section D? It is a cul-de-sac, and you will get cars parked there.
Again, it probably might be best, obviously, from a public rights of way perspective, for probably maybe Stefan or Phil to come in. But in terms of highway, because it is a shared surface, it is designed and used to facilitate pedestrians and parking. Now, with any sort of adoptable road, which obviously in this case it would be, we don't have any sort of, we've got no control over where the public park in any instance, let alone obviously on our developments, but facilitating that posed question, I suppose, is to delineate and make it very clear with signage, with markings on the ground, to make it very clear to obviously the public and the residents of that area that is a public rights of way route, which would deter hopefully anybody parking in that zone.
Okay, thanks, Tony. Councillor Phipps.
Yeah, thank you, Chair. My question is, do we think that the matter of the wildlife corridor could be resolved with a bit more time?
We'll discuss that when we take a break. Now we will have a discussion. There's a number of questions that I would like to discuss with the committee off in camera. Yeah. So before I bring you in, Mr. Wells, I'd like to bring in Stefan to garner his opinion on this alternative route.
Thank you, Chair. Which part would you like my opinion on?
Okay, the feasibility of this this route and how you think it fits in with a right of way. So it's up the ramp,
yeah,
across the road to E, round the corner, across the shade space, road, pedestrian, along the pavement, and then across the front of 3 houses, in between a number of, there's 2 garages there, and I believe a number of just parking spaces, yeah, as well.
The route itself complies predominantly with the legislation in that it's providing a route on an alternative route to that exists legally at the moment. Pedestrians will be able to walk the route. There are obviously downsides, and as it's been brought up, Welsh Government guidance is that public rights of way shouldn't be put on estate roads or footways through development. They should instead be put on open space, traffic-free areas.
So
that is guidance.
So according to Welsh Government guidance, the wildlife route would be obviously the preferred option.
Would be a preferable option, yes.
Yes,
we
okay.
have to take in equalities matters with that and accessibility, which is why the routes on the footways are useful for example, people with mobility issues, parents with pushchairs, for example, small children, and it's more accessible.
Are you saying that the route that Taylor Wimpey is proposing is a more accessible route than the wildlife corridor?
The wildlife corridor at its southern end is quite a descent down an embankment, so that's not accessible for anybody who's less able. Also, the surface is not, because it would be grassed, would not be as suitable for any wheelchair, for example, pushchair, and the usual shopper mobility scooters. Whereas the route proposed along the footways obviously is going to be surfaced, tarmac or the pavia surface.
Okay. Let me think. The northwestern end.
Yeah.
There is two proposals there. One which makes you turn right behind the garage.
Yeah.
And onto the original alignment, from what I understand. And
yes.
then there's another route which you turn left down the side of the house. Now, we visited there on site. So the question I'm going to ask is, when you turn right behind the garage, that route then would not be compliant, DDA compliant or accessible compliant?
As it stands, as soon as the land falls outside of Taylor Wimpey's ownership, the ground has been excavated there to create quite a hole. So that area then, where you would then need to cross back up onto the original line of the public right-of-way, would not be an accessible route at all without further works being carried out.
Okay, and the turning left is a more commodious route and more accessible.
The gradient is more favourable at that point to link down onto the existing public right-of-way, yes.
Okay, thanks, Stefan. Mr. Paul Wells.
Thank you, Mr. Chairman. Firstly, I'd like to address the shared access. The shared access is basically designed where the footpaths marry down to the road, so the width of the road is narrowed. Unfortunately, in that section of land there, the road has not been constructed in accordance with the planning consent, and an actual curb on the one side has been put in, a full curb, to deal with a level issue. So it doesn't actually comply, and I feel that when it comes to an adoption situation, it will not comply. And what it means is that as the road width is reduced, if two cars come to at the same time, one of them will actually mount the shared footpath so they can pass. But in this occasion, as we have a curb on the one side, it means that any cars coming to pass have to go to the area where the footpath is. So it's going to put more traffic on the footpath. And as Mr. Denby said, you can mark on the highway the actual width of the footpath, but that's still not going to stop people parking there, and it's still not going to stop people having to come across over that defined area that could be marked on a highway if two cars have got to pass. So I do not think that is an ideal situation. And if I may now refer to the section you just talked to, where you can either go left or right.
Yeah.
Still have a level issue. That ground, Taylor Wimpey's ground, is 1.5 meters higher than it should be on my ground. Therefore, if a retaining wall is built, then you may be able to do it, but you still have the level issue. It doesn't work from a level point of view. And I note that Taylor Wimpey have said that they have a plan and a design to do that. I've been requesting that design now for over 6 months, and it's never been given to us because from what our designers are saying, no, it won't work. So there is an issue, even if we get there, and as David pointed out when he spoke, there's a level issue, and that is our issue. The fact remains that at design stage, there was a level issue. There was a retaining wall there. So if you have the, go back to where it has to be, it's either a retaining wall, which is going to restrict the footpath, or you're going to have to ramp up. So it's not ideal to go in that route, and it would be very difficult to make it work.
Okay, thank you, Mr. Wells. Councillor John Ridgewell.
Yeah, thank you, Chair. I have a number of questions which I think would be better served discussed in camera, so I'm happy to leave those. But one question that I'd like to put now to Stefan is, in terms of DDA compliance, do public rights of way, in your view, have to adhere to that in the same way that our public footpaths do? Because it occurs to me there are an awful lot of public rights of way, excuse me, where it would be very difficult to have DDA compliance.
Existing public rights of way were surveyed around 1950s and therefore were just surveyed as they were. Where we're talking about putting in new public rights of way, we try to make them as compliant with the Equalities Act as we can to maintain access for as many people as we can.
Yeah, in terms, you use the word try. Can you expand on that? I mean, what is our actual responsibility? I mean, there must be circumstances, I imagine, where we have to put a detour in, and quite honestly, it would be physically impossible to provide a DDA compliant footpath.
Yes, I mean, as I said, you know, we try. I'm not aware, and Mr. Woodland might be able to clarify. I'm not aware that we have to make everything comply. We have to do our utmost to make it as compliant as possible.
Okay, yeah, thanks, Stefan. Thanks, Chair.
Okay, thanks, John. Tony Taylor-Wells, you did have your hand up. I don't know, did you want to come back in?
Yes, please, Chair. Sorry. Just a quick point referring to Mr. Wells's concern on his land to the north, where the level difference are changed. We do have a plan, obviously, to overcome any level differences, which we're willing to construct to. However, obviously, we're not obligated to provide any level of detail to Mr. Wells in terms of our design on land that we control. Obviously, we've shared it with the public rights of way and Stefan, which obviously enables us to produce that route should we need to, but just by process of elimination, I suppose, in this regard, turning left at that cul-de-sac at the bottom and avoiding that land in general would be sort of the more commodious route, which I think we touched on a bit earlier. And I suppose what we need to be mindful of in this instance is that, probably back to Councillor Phillips's question on the wildlife corridor, Taylor Wimpey are not willing to try and reach any level agreement with Mr. Wells on that wildlife corridor because we've spent 3 years trying to do so, obviously without any avail. And in this instance, you know, we need to look at the application as it currently stands, you know, and in this respect, the wildlife corridor is not included on that.
Okay, so you were saying that Taylor Wimpey are no longer are now refusing to enter into any conversations around the wildlife corridor and the access across Mr. Wells's ground.
Correct, Chair.
Right. Okay, so that's an absolute no. Okay, so as long as we know the position, Mr. Donovan.
Coming back in with the lady that just spoke from Taylor Woodrow, they made a contract effectively, and to actually turn around and say now that they won't speak to the landowner, where does that put the council? Well, I mean, they've made a contract with us, Philly Council, and now you get them dictating to you that they are not going to deal with the landowner that they promised the corridor to go on. It can't go on like that, Mr. Chairman. That's a disgusting attitude.
Yeah.
And exactly what I was trying to point out when I spoke last. I'm feeling quite annoyed with that statement that that lady just made, and
Yeah.
I think the council should on that basis. They are dictating to you. I think we should dig in and say, look, comply with your contract. And that contract was this wildlife corridor. Had we not been offered that, then we wouldn't have agreed to it in the beginning.
Okay.
Belief to me.
Thank you, Mr. Donovan. I can assure you that the Taylor Wimpey are not dictating to us. What I'm doing here as the chair of this meeting is trying to find out everybody's positions, everybody's stance, and then there's no doubt that there is some difficult discussions to be had between the committee members on this, and there are many sides to this argument, and ultimately we could, you know, there are the four options available to us. We could extinguish the path, we could knock 3 houses down, we can agree that route, you know, all those things are to be discussed later. I can assure you they are not dictating to us.
I appreciate your position, actually, but having said all that, it is still a contract that they made. They built over the existing footpaths. They should now pay for it. It's as simple as that, in my opinion.
Okay, thank you, Mr. Donovan. On Mr. Donovan's statement there, I would like to ask Mr. Shakespeare, was a contract made? Was that the initial outline of the design was to put the footpath through the wildlife corridor?
Well, that's what they offered, and that's what we, as in my position, for when that's what we accepted.
Yeah.
We carried on from that point.
Okay, thank you, Mr.
I
Donovan.
don't want to go any further, but I'm not quite sure what the council's involvement was from that point on. I assumed that they just the council looked after it, their officers looked after it, you know, but obviously Taylor Woodruff went ahead knowing damn well that they didn't own that land, and yet they were offering us this corridor.
Yeah. Okay, Mr. Donovan, thank you very much. Mr. Shakespeare, do you want to reply?
Yes. So, I mean, obviously, I've only been involved with this for about 5 years, so I haven't got a complete history. But my understanding, I mean, firstly, there isn't an agreement about this. Certainly not in a contractual sense. My understanding, and Tony might be able to expand upon this, is that when Taylor Wimpey acquired the site, of course, they thought that the footpath had already been diverted. I think there was some issue about the footpath originally, which turned out not to be correct. Now, the position as it stands is that Taylor Wimpey has made an application to divert the footpath along, and there are a number of route options which you've all seen. Now, all of those route options are within Taylor Wimpey's power to control and deliver. As I explained earlier, you know, Mr. Wells has raised a couple of objections. Either we think he's just wrong, but even if he's right, the diversion can be dealt with so that, for example, the ramp can be altered, so that even if he's right and he owns that piece of land, the diversion route will not impact on it. In relation to the levels at the northern end of the site, that's on land that this diversion doesn't touch. It's irrelevant. He might have an issue with Taylor Wimpey, he might have an issue with us, and he might bring a claim for breach of contract against us in relation to the agreement between us and him relating to this development land. But that's irrelevant to the route of the footpath. The footpath can be delivered. It can all be delivered on Taylor Wimpey's land. Now, I think everybody agrees that the wildlife corridor, subject to the point about accessibility at the southern end, certainly at the northern end, the wildlife corridor would be a better option, but it's not available. It's not the subject of this application for a diversion. It's not an option which is on the table for the committee, and it's not an option that's open to Taylor Wimpey because Mr. Wells is not prepared to transfer it to us. Now, I know he says he is, but he is subject to a ransom, and Taylor Wimpey is not prepared to pay that ransom payment. So that wildlife corridor is a complete red herring so far as we're concerned. And as Tony said, we've been dealing with Mr. Wells for a lot longer than the last 3 years, but we've been dealing on this and other issues for at least the last 3 years, and there is no point continuing or going into further discussions because we are not going to agree. And Taylor Wimpey is not going to pay that ransom that Mr. Wells is trying to extract.
Okay, thank you, Mr. Shakespeare. But obviously you are aware that we can make an order to divert the route, extinguish the route, enforcement action to remove the obstructions. On a different route to that, so by the applicant. And there is an option on there for us to divert the route onto a different route than that sought by the applicant. So we can, we are legitimately looking at those options, the 4 options that are on the table there for us.
Yes, of course.
Yeah.
And you know, there is the well, perhaps the likelihood. I appreciate that, you know, the situation that the council is in, but you know, depending on what decision you make, it is likely that there is an objection that will come from one direction or the other.
Yep. Okay. Thanks, Mr. Shakespeare. Mr. Wells, did you want to come back in, or is that an old hand?
Yes, Mr. Chair. I just wanted yourself and the committee to be clear. We will transfer the land at nil value. We, as a company, will get nothing out of it. All we're looking for is to recover part of our legal costs. I made it very, very clear at the last meeting that the costs that have been spent on the legals there, so they are. And I understand what you're saying, Mr. Chairman. You have the ability to direct that path to go down the wildlife corridor, but it's disappointing that you're using the word ransom. It's not ransom. It's money that we've expended trying to reach an agreement with Taylor Wimpey. And
Mr. Wells, it might be pertinent then if, look, you don't have to tell us how much it is one way or the other, but it might be helpful for the committee if they know that if it's 50 quid or 500,000.
It was £40,000. It was well stated and documented and minuted in the last meeting. Right. It was £40,000. It was agreed by Taylor Wimpey's solicitors that figure would be paid as part of the overall package.
I'm sorry,
that's
detail that is subject to legal privilege between Taylor Wimpey and Mr. Wells and his companies. That relates to a dispute. He has incurred costs in relation to that dispute. Mr. Wells is not entitled to that money. He's asking for it, and that's why we're describing it as a ransom. It is not money to which he's entitled. If he wanted to bring court proceedings, that will be up to him, but he hasn't done that. It is costs that he incurred in failed negotiations, and the subject and detail of those negotiations are legally privileged.
Okay, thanks, Mr. Shakespeare. So I believe personally, and I would ask this of Mr. Wells, that you should be perhaps, and if this was to be considered, that rather than considering passing the land on at nil cost, that you could actually
Chair,
put a price on the land, and you can deal with your own legal matters. Mr.
Chair,
Secretary.
sorry, because Mr. Wells may want to deal with this point as well, so sorry to interrupt. But the other point that Tony's just reminded me about is that the other issue is that Mr. Wells wanted to transfer the wildlife corridor to Taylor Wimpey, but one of the issues that remains outstanding is that there is a significant commuted sum. I forget the amount, but I've got a feeling that it's more than the £40,000 he's already asking for. That would be payable under the Section 106. So that's a liability that he still has in relation to the wildlife corridor, which he wanted to pass on to us as well as a condition of transferring the wildlife corridor to us. At the moment, that is a commuted sum that's payable by him once the wildlife corridor is complete and it's been adopted by the council. So it's not just the £40,000 that he wanted us to take on. He wanted us to take on that liability as well, which again is something which Taylor Wimpey is, that's a liability for him. It's not a liability for Taylor Wimpey.
And that commuted sum is, forgive me, that's the monies that would be passed on to the council for them to
yes, it's the future
adopt
and
the future maintenance of it. Okay, thanks very much. Okay, Mr. Wells, you still got your hand up. Did you want to come back in?
Yes, Mr. Chairman. Yes, it's quite right. There is a disputed commuted sum to be paid, but we have to remember that this was part of an agreement. As Mr. Donovan has pointed out, it's been going on for years. It has always been from day one that the land would be transferred at nil value. The costs of £40,000 legal fees were agreed. It's documented. They were agreed, the £40,000, and the commuted sum was there. And I have the evidence to prove that. The situation is the same. Taylor Wimpey withdrew from the agreement. The settlement agreement that incorporated this footpath, Taylor Wimpey withdrew from that agreement. They give us 24 hours notice and they withdrew from it. Nothing from our point of view has changed. We'll still transfer that land if our legal fees are paid.
Okay,
they're capped at 40,000.
Thanks, Mr. Wells. I'm going to ask, I'm going to take a final contribution from Tony Taylor Wells before I'm going to call for a comfort break after that. Tony.
Thanks, Chair. Respectfully, Paul, I hear everything you're saying. I think, but the matter still remains that, there are conditions related to that wildlife corridor. As David rightly said, there's the legal fees that are in excess of any transactional costs to transfer that wildlife corridor that relates to other contractual issues that obviously both companies have, and is not really pertinent to this public right of way, which I think we, for the avoidance of bringing in contractual disputes, which I think was not within anybody's interest, we really do need to try and sort of stick with focusing on the application as it currently stands. And again, Mr. Donovan, I'm sorry that you were under the impression that there was an agreement. Initially we did try and reach agreement with Mr. Wells in putting the public right of way through that corridor again, but because of the ongoing contractual disputes between both companies, that option isn't no longer viable due to previous objections raised by Mr. Wells on us putting it on their land. Again, linking back to other commercial aspects and disputes. So, again, regrettably, I'm sorry that you do feel that way. And yeah, if there's any questions, obviously, just please just shout.
Thanks, Tony. Mr. Donovan, I'm not going to bring you back in, or Mr. Wells. I'm going to be calling for a comfort break now. We're going to finish now at 11 o'clock, and we will reconvene at 11:30. Before we go, it would be remiss of me not to mention that in the last meeting, there was representation from local councillors on behalf of the residents, and very much stating that the local residents there seem to be very much not in favour of the path running through the centre of the estate. That was the gist of it. And I just wanted to remind, I'm sure that the councillors sitting around the table here are all quite aware of it. I just wanted to mention that representation was made, and that also is part of the consideration. So I think if we adjourn the meeting now and we'll reconvene this meeting at 11:30, and I would like to ask the councillors and certainly Mr. Denbury, Mr. Martin Woodland, and perhaps Mr. Griffiths, if we could convene at 11:05 in a separate meeting. There are a few questions that need to be answered on an internal basis before we come back to further deliberations in public. Is that okay?
Absolutely fine. Thanks, Chair.
Okay, thanks very much. Okay, Charlotte, you can stop the recording now.